Thank you very much. Dr. Jason Squire, the Director of Raoul Wallenberg Institute's Jakarta office, Professor Dato Dr. Rahmat Muhammad, Chairman of the Human Rights Commission of Malaysia, SUHAKAM, Mr. AmerBON Tai Soon, Head of Chambers Civil of Messrs. AmerBON, Honorable Judges, Judicial and Legal Officers, Lawyers, and esteemed participants. Assalamualaikum warahmatullahi ta'ala wabarakatuh. And a very good morning. Being here today is indeed an honor, and I bid a warm welcome to all of you. I take this opportunity to congratulate the organizers, RW1, SUHAKAM, and AmerBON advocates for initiating this event, as the cause helps shed light on the role that each of us must play in the larger conversations surrounding the environment and human rights. Thank you also to the organizers for this invitation to deliver the keynote speech to this important course entitled the Blended Learning Course on Human Rights and the Environment, Climate Change, Cycle number 3. I have been tasked to speak about the power of adjudication in protecting the right to a clean and healthy environment, opportunities and challenges. The blended learning course addresses salient concerns on the regulation and protection of environmental rights across various regulators and legal players. The right to a safe and healthy environment in Malaysia is not new. The many impediments to its full operationalization are known. The courts and human rights institutions have a role to play to support the right. More work needs to be done to ensure that the right is more adequately protected. The right to live in a reasonably healthy and pollution-free environment is recognized and is within the ambit of the right to life and personal liberty as guaranteed under Article 5 of the Federal Constitution of Malaysia. Malaysia has made advances towards the Sustainable Development Goals that include climate change action, clean water and sanitation, good health and well-being, while developing strong peace and justice institutions. In determining how the right to a safe, clean and healthy environment applies in a practical sense, one must acknowledge that there has been an increase in public awareness and thus public pressure to stop air, noise and water pollution while maintaining our green spaces. Economic development has taken a heavy toll on our rich natural resources of our land and water. While there are laws and regulations to prohibit, regulate and manage commercial initiatives that adversely impact our resources, more can be done. A prevention rather than cure approach is extremely important to ensure that continued environmental degradation and destruction is stopped, and that should be the preferred approach. Malaysia should consider a move towards fully embracing and adopting the polluter pays principle, whereby those who pollute should bear the cost of managing or mitigating the damage to human health and the environment. Further, businesses must adopt due diligence mechanisms in their practices and report the same publicly for robust scrutiny. The aim of the due diligence is not to show off or to satisfy the regulators, but to genuinely use it as a form of feedback mechanism for companies to self-check their practices. We read about the many sad cases of environmental exploitation in our country, and it is no wonder that the media and citizens are calling for more direct action to stop such abuses. Judges have a duty in the judgments to respect, protect, and enhance environmental rights. Procedurally, it includes looking at ways and means to increase access to remedies for those human rights have been adversely affected by environmental harms. We have Article 4.1 of the Federal Constitution to strike down any law or executive action which are inconsistent with fundamental liberties provided for in Part 2 of the Federal Constitution. While not expressed, environmental rights could be implied under Article 5, Clause 1. The courts have additional powers under the Schedule of the Courts of Judicature Act 1964 to judicially review decisions or actions or omissions of persons in authority that jeopardize the environment and make such orders as are necessary to remedy those adverse impacts. To punish those who harm the environment, there is the possibility of initiating criminal prosecutions under the powers of the public prosecutor. The criminal courts introduced the element of deterrence through its penal sentences, unlike in civil actions. The gravity of environmental offences cannot be downplayed. Serious cases such as water pollution have caused death and irreversible ill health. Criminal court sentences should reflect the seriousness of the cases according to judicial precedent and subject to mitigating factors. The statistics reflect that in Malaysia currently, criminal environmental cases registered in the courts are significantly higher as compared to civil actions. The total number of environmental cases registered at the High Courts, Sessions Courts, and the Magistrates Courts nationwide from 2017 until August 2022 is 113 civil cases, which makes up 2%, and 5,965 criminal cases, which makes up 98%. The strict rule of locus standi may be a reason that hampers the progress of public interest litigation of environmental issues in Malaysia. Courts have been rather inconsistent in their interpretation of locus standi. In the Court of Appeal case in Kajing Tubak, we saw the creation of a threshold locus standi and substantive locus standi. The Federal Court in MTUC, in determining locus standi, has defined the term adversely affected in Order 53 of the Rules of Court 2012 to mean the real and genuine interest in the subject matter. In this regard, the Philippines has advanced leaps and bounds by according locus standi to even unborn children to bring environmental actions. Constitutions in certain countries have explicitly defined locus standi. Pakistan and Bangladesh use the term aggrieved person. South Africa, just like us in our Order 53, uses the term adversely affected. UK uses the term sufficient interest test. Canada uses the term directly affected, and Australia adopts the term person aggrieved. Now is definitely an opportune time for Malaysia to look into specific environmental rights laws to expressly protect everyone from adverse environmental impact. This move may include amending the Constitution to broaden Part 2 by adding the right to a safe, clean, and healthy environment as a fundamental liberty. Only then can we be assured that this right ensures to the benefit of our children, grandchildren, and the future generation, and that it will not be so easily taken away. On the part of the courts, the discussions previously conducted with the Attorney General's Chambers, the Judiciary, and the Bar Council on amending the rules of courts for greater public participation and to broaden local standard should be reignited. The bridge that closes the gap between what the courts can do and the more practical issues of preserving rights to the environment is effective cooperation. Malaysia has no less than 38 acts and ordinances, as well as a sizable quantity of subsidiary legislations relating to the environment in its arsenal. The number of laws, however, serves no purpose without effective and genuine enforcement. National human rights institutions such as SUHAKAM play a significant role to integrate human rights considerations into the narrative of environmental and climate change legal cases. Synergy between the courts and these institutions is crucial. There is a pressing need to afford protection to human rights defenders from threats and harassment, and to better limit the use of strategic litigation against public participation to silence dissent. We have seen alarming environmental impacts of massive floods from heavy rains due to global warming, water cuts and shortages due to pollution of the rivers, mismanagement of our river basins and deforestation, massive reclamation projects, and the destruction of environmentally sensitive areas. The number of climate refugees around the world is increasing by the day. As such, the pace of implementation of our joint and collaborative commitments to transform the way we do things, especially by businesses, need to be followed through. A paradigm shift in the way companies are to approach their operations and in treating our natural resources is already institutionalized in the United Nations Guiding Principles on Business and Human Rights, UNGPs. The UNGPs encompass 3 pillars outlining how states and businesses should implement the principles, namely, state duties to protect human rights, corporate responsibility to respect human rights, access to remedy to survivors and victims of business-related environmental abuses. I understand that the government has committed itself to launching a national action plan on businesses and human rights in 2023, and we can then look forward to seeing how the plan will better protect human rights and the environment. As a reminder to all of us, I conclude by saying that as Mother Nature is our shared home, let us do our part in protecting it so that it can continue to sustain future lives beyond ours. Finally, I must commend and thank the organizers for their effort in making this program possible, and I wish all of you an insightful and productive discussion. Thank you very much.